I was the prosecutor of this case and made the investigations, wrote the indictment, and represented the prosecutor's office at the trial. First, I want to tell you some background remarks. During World War II, John Demjanjuk was a soldier of the Red Army. He came in German captivity in May 1942. A few weeks after his capture, Demjanjuk was selected by SS officers for the so-called Fremdvölkische Wachmannschaften, what means foreign nationalist guards. And then he received military training for several months in the Travniki training camp, from which he was discharged with the lowest grade Wachmann, which means security guard. Presumably, Demjanjuk was detailed on 27 March 1943 to the extermination camp of Sobibor in Poland, where he was involved, presumably, in the killing of about 28,000 Jews until the end of September 1943. After the war, he immigrated to the United States of America, where he then lived in the state of Ohio. From about 1977 onwards, authorities have dealt with Demjanjuk's history. In Israel, he was charged to have murdered Jews in the extermination camp of Treblinka. In 1988, the Jerusalem District Court in first instance imposed him the death penalty of him, and in 1993, the second instance court acquitted him. Then he's set free, he returned to the United States. In 2008, the Zentrale Stelle der Landesjustizverwaltung in Ludwigsburg, its German office, the Central Office of the State's Justice Administrations, decided to make pre-investigations against Demjanjuk with regards to probable offenses committed in Sobibor. After 1 year of pre-investigations, they sent their files to me, and after additional 6 months of further investigations, I filed the indictment against Demjanjuk in July 2009. There was some special problems of the case, which I want to tell you in following respects. The first one difficulty lay in the huge amount of evidence material to be collected from the whole world. USA, Israel, Poland, Ukraine, Russia, and of course Germany. The case therefore was an extraordinary one, with lots of references to countries abroad. I went to USA, Israel, and Poland to collect evidences. Second, the evidence itself was of course either difficult. The criminal act was committed before almost 70 years, and there weren't any eyewitnesses alive anymore who could report on Demjanjuk's activities in Sobibor. That forced us in the opposition to rely on historical documents, especially this Ausweis, security identity card. It's a copy, not the original one, of course. The original one is back in the United States. And especially on experts. In this respect, the case makes a big difference with the antecedent trials. And legally, we couldn't apply to today's constructions of criminal enterprise. Probably you know this construction. This construction was not possible in this case. Our conclusion was to say it might not be exactly clear what Demjanjuk did in Sobibor, but any of his acts in Sobibor was part of the extermination happening there. Guarding the extermination camp compound inside or outside the camp. So, it is necessary to point out the difference between guarding an extermination camp and a concentration camp. In an extermination camp, the only purpose is murder. So you can say that any action performed there is associated with murder. Therefore, it is illegal, is legally irrelevant that a concrete act of Demjanjuk to a concrete murder couldn't be proved. But we had to prove, of course, the guard's activities in reference to the murder process. And This was possible because of our experts. So we had also legal problems, of course, and the main legal problem lay in the defense of exculpation. The German Supreme Court has pointed out this problem in general. Grounds of exculpation may only be invoked if the person has tried to avoid criminal offense conscientiously. The person may not choose the easiest and most convenient way for him in resolving the conflict. Of course, there must be a possible way out of the conflict. However, a certain risk is reasonable. This was our German Supreme Court. So, this context, it had to be noted that Demjanjuk could escape actually the German service. This was for me the most difficult point of the proceeding. Because German post-war jurisprudence, some former German guards were acquitted by reason of putativ Befehlsnotstand. It's a German word. Perhaps you could translate it in imaginary reason or situation, imaginary necessity or situation erroneously regarded as an emergency. This is given when the offender thought there was an emergency because he could not refuse the order, otherwise he himself would be killed. Therefore, it required great proof and justification afforded by a former prisoner of war. Demjanjuk was a former prisoner of war. Won't get this kind of exculpation. In conducting the investigation, in the facts, I tried to use all possibilities to clarify the question whether Demjanjuk could escape from the service. As nothing was known about the personal situation of Demjanjuk in Sobibor, no eyewitness, we had to deduce from the general situation of his colleagues in Sobibor to the possibilities of an escape of Demjanjuk. This was also the hour of our experts. My closing argument, which the court accepted, was that Demjanjuk had a chance to escape if he had made appropriate efforts. In spite of risks, there would have been chances of success. Other people have successfully realized their escape. We have to imagine there were 150 Travniki men, some guardmen, in a ratio of 20 to 30 German guards in Sobibor. And he had a gun, Demjanjuk had a gun, and could go around the compound. On 12 May 2011, the court finally found Demjanjuk guilty of assisting murder in totally 28,060 cases. The court imposed a term of imprisonment of 5 years and lifted the arrest warrant as there was no more danger that he would escape. It was 2 years in jail. The verdict did not become finally valid because Demjanjuk died on 17 March 2012, before the completion of the legal review confirmed Demjanjuk's acquittal. Conclusion. What differences between past and now could we see in this case? First, in the past, there were a lot of eyewitnesses. They identified the perpetrator and described his activities. Now, as experts describes the activities of persons because no eyewitnesses are alive anymore, but the experts describes the activities of persons who had the same rank as the defendant. The court deduces from respects to the activities of the defendant. But there's no difference in one point. Media often say that since the Demjanjuk verdict, it is sufficient to prove the presence of the perpetrator in an extermination camp. Only the presence is enough. But however, former verdicts also convicted persons by reason of murder on hundreds of thousands of people due to their function in an extermination camp. This is new, not new. New is only that nobody identified the perpetrator, Demjanjuk, at a certain moment in Sobibor. So the court had to establish the fact of his presence there through documents that showed Demjanjuk was in Sobibor at a certain period. That he was actively part of the extermination in 28,000 cases was founded upon the expert's statement to the activities of the guards. Second point, So differences between past and present is past, but German people in power with a higher rank only were judged. Now, lower rank officials can be indicted, even a person from abroad. Demjanjuk was the so-called small fish, he was only a small guy. And another difference, courts often gave the defendants an easy possibility to invoke imaginary necessity. Now the courts say even the lower rank official had the chance of choice whether he takes part in the murder or refuses to do so. So let me close with some humanitarian remarks on the trial against Demjanjuk. It was of course a case of even political sensitivity. It was a crime of the state, and Demjanjuk was assisted this crime of the state. Although the crime was of course common law, murder. So in my opinion, it is especially necessary to take care of the defendant in political cases. Demjanjuk so got 2 defense counsels assigned even before Demjanjuk was brought to Germany. Even the obstructing lawyer, that a very difficult lawyer, was paid from the budget. And second, the court took special care of age and health of Demjanjuk. He was 90 years old. A physician was present in the courtroom, and Demjanjuk lay in a convenient bed. Picture here from the courtroom. It was Demjanjuk in the wheelchair, and beside is his bed, and behind him you see his physician. And this is Demjanjuk to see better in his future. And the hearings did not last longer than 3 hours per day, so we had to special care of this. And the evidence was thoroughly collected, and the elements of guilt were carefully established by the court. At last, the trial was only about to find the individual guilt of Demjanjuk. He tried to avoid a show trial with educational or didactical aims. So we wanted to stay close to the case and not to work off the Nazi crimes in their entirety. It's possible, but we don't want to do this. Thank you.